Welcome to this latest edition of Legal Considerations with Judy Donegan. During the week of April 22nd, 2024, oral arguments were heard in the Supreme Court over two separate cases. Moyle versus U.S., where the Idaho abortion ban was proposed to supersede the federal Emergency Medical Treatment and Labor Act, EMTALA, and the Trump immunity case, which was heard the very next day. With me to give her analysis of both proceedings is Judy Donegan. Welcome, Judy.
Hello, Paul. Good to see you.
Good to see you again. My understanding of Solicitor General Prelogger's position on EMTALA is that when any person goes to any emergency room, the hospital is obligated to treat the patient and not discharge them if their condition is likely to worsen if not given proper treatment. In those cases where an abortion is needed so the woman wouldn't later suffer from sepsis, loss of kidney or uterus, or the capability to have children in the future, the hospital should be able to apply said treatment if their medical judgment reaches those conclusions. The Idaho law says that only if the life of the mother is in immediate danger can an abortion be allowed. Josh Turner, the lawyer representing Idaho, claimed that the state law must take precedence over the federal law. Is that your understanding of their respective positions? Judy, is there anything to add?
Well, I think that is what it boils down to. But I think Turner knows he's on kind of shaky ground here. So the argument's a little more convoluted than just claiming that state law takes precedence. So he's saying, I think, that, and it's a little hard to tell actually, but that the state is responsible for licensing doctors. And in Idaho, the doctors have to comply with Idaho abortion law. EMTALA requires that you have to stabilize the patient to the extent that you have the staff and resources available to do it. And this is where he inches himself in here. If you have no doctor licensed to perform the abortion, then you don't have the staff to do it. So that's why he thinks they don't have to comply with EMTALA.
And then because Idaho law says that the licensing is prohibited for abortions,
Right.
then therefore there couldn't be anybody, even if they went through all the rigorous medical training to be able to do that.
Well, and I'm sure they know how to do it. You know, I'd like to know what the license says. And I think that the did you notice the analogy he kept giving at least two times of the fact that if a nurse knew how to perform open heart surgery, she wouldn't be allowed to do it? I mean, that's a pretty weak analogy, I'd say. And then also, I doubt that many open heart surgeries are conducted in the emergency room. So his argument just kind of rambles all over the place. And I think that's in part because he knows that federal law preempts state law when there's a conflict, and he knows about the supremacy clause. So he has to convolute his way to this position he is taking. That's my view.
Yeah, funny thing about that supremacy clause. I think you're right. I think he did know about it, but it doesn't seem like Alito knew about it.
I'm pretty sure they all know about it, but they are deliberately blind to these things sometimes.
Yeah, deliberate blindness. Okay, the first thing I noticed from the questions to Turner was the clear understanding from the female justices of how women's bodies function, from the reproductive organs to the variety of problems that could occur with pregnancy, while Turner knew very little about that. Is that what you heard?
Yeah, I'm not sure what Turner knew, but here's another place where Alito and company are deliberately blind. Uh, I have to think they know more than they were letting on. Um, and it's almost as if they are basing their statements on somehow this fetus is supposed to survive by itself. It cannot survive without the mother. If the mother's health is seriously threatened, and if you're going to let her go to the point of death before you do something to her, there is no way that fetus, an early term fetus, is going to survive. So it seems to me, and I think that Prelogger pointed this out, that what you're doing is causing two deaths, one totally unnecessary and one that's a result of the first one. Um, so it sort of it just is an illogical position to me.
Yeah, we're going to talk about the Prelogger's knowledge of that whenever she was confronting Alito on that later on with a different view. I'm sure you're aware of that. The male justices wanted to focus on the fact that Impala was a spending bill passed by the feds to ensure that federal funds supporting medical facilities required them to follow a standard of care to maintain their eligibility in keeping those federal dollars. But since the federal law is a spending law and the Idaho law is a criminal statute, isn't crime law more important? At least that's the impression I got from Alito. Did you get that sense from the male questioners that they were using this fact that it was a spending bill and Idaho was a criminal law? And so, we have to take care of the criminal laws first because spending bills they're not nearly as important.
Yeah, you did. Well, that was the question they asked. I'm not sure
Clarence Thomas, that was the first question Clarence Thomas asked. That's when he opened it up with that.
Yeah, yeah. And the annoying part about that is some of these things in both of these arguments we're going to discuss just are all over the place, and they're not grounded in what the arguments were below in the lower courts. So even though Idaho tries to argue they did kind of mention this, it really apparently wasn't a part of the case below, and you know, they're not supposed to be doing this.
When Clarence Thomas asked Prelogger to cite examples where spending bills preempted criminal law, she rattled off a bunch of cases. When Alito asked, how can you impose restrictions on criminal law? Prelogger again cited numerous examples, but what struck me the most about the exchanges between Alito and Prelogger when he asked if the standard of care extended to the unborn child, Prelogger's knowledge, which you cited earlier, Judy, that the chances of a 10-week zygote had to survive under these conditions was zero. And her simmering agitation of Alito's stupidity in his engagement of the gotcha game he loves to play was clearly evident in her voice. Did you see Prelogger's patience with Alito's nonsensical ineptitude reaching critical mass? Now, I have so much respect for the demeanor that Prelogger, the Solicitor General Prelogger, carries, and she just was like, she kept her cool, but you could see, she was really starting to get impatient, if I could use that word.
Well, yeah, she was a little curt with him, and I think he deserved it. Well, it is the end of the term, and this woman has argued, I don't know how many cases in front of these people, putting up with this sort of thing day after day. So I guess it's no wonder. One thing that I liked about her response when she, when she was getting a little annoyed, she did not use any euphemisms. She talked about the need for abortion, not, the care for the woman's health. She talked about abortion, and she talked clearly about federal supremacy. And I think at one point stated that she believed strongly in federal supremacy. So, that was sometimes people will argue and use a few euphemisms and not try to confront things that directly, but she wasted no words on that. She was direct.
Yeah, she was direct, and the Alito was anything but direct. He just like skirts and skirts around things, and yeah, I really appreciated the fact that she was starting to say, "Okay, pal, I've heard enough of this," but she didn't say. I mean, she is so good at not losing her cool that but you could see in her, you could hear it in her voice on this particular issue. Okay, the immunity case arguments. We're moving on to the other case, one they had the next day. It really raised my hackles. Again, all four women really seem to care about the problem an unrestricted criminal in the Oval Office presents to our future. While at least three of the men, Gorsuch, Kavanaugh, and Alito, twisted unbelievable hypotheticals to protect Trump. What did Justice Roberts and Thomas tell you from their questions and demeanor? Those guys seem to be like staying in the background a little bit, while the other three men kind of like, headed headlong into the Trump protection racket.
True. Well, it was really hard for me to tell about Roberts at all. He really did stay in the background, except he doesn't like the Court of Appeals decision. And that was pretty clear. But Thomas, his first question, as I recall, was, where do you find immunity in the Constitution? Which sort of took my breath away. I mean, why is he asking that question? It is not in the Constitution. So I'm thinking, what is he up to? And it did give Trump's lawyer a chance to argue that the vesting of the executive power in the president was where you found it. But that seems to be a pretty weak argument. Um, so, and then uh, what was he doing? What was Thomas doing when he mentioned Operation Mongoose, which I had to look up? It was the coup attempt on Fidel Castro, supported by the Kennedy administration. And why wasn't Kennedy prosecuted when he was a former president? Well, I don't think he had a chance to become a former president. I mean, what kind of question is that? So I'm not sure what he was up to.
I think he was trying to protect his wife. That would have been one of the things that
Well, that was what I assumed at first. I mean, originally, yeah. Why else is he on this case? He should not be on this case.
he should have recused immediately. I mean, his wife was in the middle of all
Right.
this. Trump's lawyer Sauer made some incredibly outrageous statements in his arguments. That guy kind of sounds like Robert F. Kennedy with his voice. I don't know if you noticed that. Very, very irritating.
Oh, he did. Yeah.
Yeah, yeah. And Kennedy was on Ari Melber last night, and we just had to like leave the room. We couldn't listen to it anymore because his voice is just so. Anyway, that's way off topic here.
Well, it is,
Yeah,
but I don't like to criticize other people's voices, given
that's
mine.
your sounds fine to me, Jude. He made some outrageous statements in his arguments, such as the fake electors were not fraudulent; they were alternate. But he seemed most focused on the notion that Trump committed official acts as president and private acts as a candidate. Didn't seem to be much interest in combining the official and private under the single category of criminal, which is what was obvious to me. But it seemed that the whole purpose of placing such a huge emphasis on the distinction between official and private was to convince the court to remand the case back to Judge Chutkan's district court, so she would have to hold hearings and issue decisions which can be appealed, thus sending the whole process well into the future. Is the strategy not necessarily to win the immunity issue, but more importantly, to delay the trial? That was my impression, Judy. Was that yours?
Well, they're certainly doing a good job of delaying. Not only in this case, but in a couple others all of a sudden. Um, but
Every
actually,
place but Manhattan. Every place but
yeah,
Manhattan.
really.
Yeah.
the court actually set this case up itself, as I understand it. They wrote the statement of the argument, and it sets up this dichotomy. I'll read it. Whether and if so, to what extent does a former president enjoy presidential immunity, my voice, for a criminal prosecution for conduct alleged to involve official acts during his tenure in office? So it looks like they decided that ahead of time.
Yeah, and they decided that, but they didn't really talk about that. Now,
Well,
Barrett did. You
she
know,
did very clearly.
yeah, she had sour lists, but different not necessarily hypotheticals, different things that were in the indictment. Said, was this private, was this official, was this private, was this official, and he pretty much said what he thought was.
Right.
But that wasn't at all the interest in Gorsuch, Kavanaugh, and Alito.
No, as your next question implies.
I better get to it then.
You better.
It was clear from the outset that Kavanaugh, Gorsuch, and Alito had no interest in the facts of the case, because every time they laid out their maggot hypotheticals, Dreeben, which is the attorney representing Jack Smith, would answer in terms of relevance to the case. They would interrupt with, I know, but let's just put that aside for now. Or, I understand that these are the facts, but my question is about the future possibilities for the ages, is one of the things that Gorsuch said. Any excuse to avoid what was in front of them. What did they sound like to you?
Yeah, they don't want to even mention, they did not, the three of them, as far as I can remember, never talked about what Trump had done or what the allegations of the indictment were.
And none of it mattered to them. None of it
No,
mattered.
because that is not, Gorsuch said, I'm not interested in this case so much as future situations, which is, I was shocked by that statement because, and all the others, they kept saying it. But, traditionally, as Ketanji Brown Jackson pointed out, what they're supposed to be considering is the case in front of them, the facts that are there, and decide that case, not try to write some future law based on thousands of hypotheticals that they seem to be able to come up with. My question is, how in the world would you write a decision like that? I, it would be easy enough to write a decision based on the facts of this case. You can decide one way or another, on whether the official acts are official and whether there's immunity for them. But when you start ranging all over about what a president might have done in office and where the lines are without any clear basis in the record of the case, uh, I don't, I've never seen them, or I've never heard of a court doing that quite so blatantly as they did in this case. And now I haven't heard every argument in the world, so of course I don't know that. But Roberts, his famous statement, if it is not necessary to decide more to dispose of a case, then it is necessary to not decide more. So what are they doing? I don't know.
So did he say that in this case?
No, that was a long time, quite a long time.
That's what okay, so I thought. So I think you brought up an interesting point, and that is, how are they going to write their decisions? Because it seemed to me that they wrote how the arguments were to be framed, which was whether it's an official act, the criminality of official act, but they didn't seem to have any interest in addressing that particular aspect of the case. So whenever they come up with a decision, do you think they're going to be like all over the board again, like they were with the oral arguments, or do you think they're going to be constrained to do what they asked themselves to do with these oral arguments? What do you think?
Yeah, or they're going to be constrained to Trump's case, which is what they should be deciding, not the case of, they kept worrying about some future president being indicted for some act. I mean, the offensive part, I'm not answering your question, but the offensive part to me was especially Alito's assumption that from this moment on, every president's going to be corrupt, you know, and they're going to, are they worried about Trump's call for retribution? I don't know what's going on, but it's hard to tell how they're going to write the case. Are they going to settle down from their grand pronouncements and hypotheticals to look at the actual facts of this case and decide it? Who knows?
Well, that was probably the most ridiculous hypothetical of the ages when Alito said, well, if a president feels he's going to be prosecuted when he leaves office, he may have to stage a coup.
Exactly.
Which is what Trump did because he was guilty of criminal activity. Yeah.
I
So
know.
let's worry about that part. Yeah. Okay. Kavanaugh clearly won the award for the most hypocritical when he began questioning the structure of the special counsel's mandate. This is the same Brett Kavanaugh who, as a member of Ken Starr's unit, got Paula Jones to file a sexual harassment civil suit in order to depose a sitting president, that being Bill Clinton, so he could ask questions about a blowjob he got, not from Ms. Jones, but from Monica Lewinsky. But the worst thing he said was that the Ford pardon of Richard Nixon proved to be one of the better decisions in our history. That pardon paved the way for Trump's presidential criminality and is a major reason why we are in this mess. How do you feel, Judy, about Kavanaugh's contribution and his assessment of the Nixon pardon? Did that rankle you like it did me?
Maybe not quite as much, but it shocked me. It was, well, first of all, he said that he thought most people approved of it now. Um, I think maybe your evidence that they don't. And I'm not sure that is true. And also, why would Kavanaugh bring up the special prosecutor? Um, isn't he? I mean, I think I read a long time ago that he was working for Ken Starr, of course,
Right,
and
right.
I think I read that he is the one responsible for putting a lot of those lascivious details into the Starr report. So it seems like that would be something I'd be quiet about. Plus, it has absolutely no relevance to this case because the special prosecutor, is that what we call it?
Mm-hmm.
That law has expired, and the
Correct.
special counsel is a different animal uh, under the Justice Department, whereas the special prosecutor was not. So I don't know why we're talking about that at all.
Because they're so arrogant, they believe they can just go ahead and throw everything against the wall and nothing's going to stick because they're immune from any kind of accountability. That's my answer to your question as to why
Well,
they
they
would do
are
it.
immune, pretty much. Okay.
A new phrase I first heard during the immunity hearing was the clear statement doctrine. And I kept waiting for some contextual clue to help me figure out what they were talking about. When I finally realized it was some more made up shit like major questions and historical analog phrases they used when they needed to justify their unpopular views. This clear statement, from my understanding, is that when the president is not specifically named in a statute, it does not apply to him. So when Congress passes a law making it illegal to participate in an insurrection, it must state clearly that the law applies to the president, because without that clear statement, he cannot be included as a violator of the law, even if he was factually involved in the crime. Is that what it means to you, or am I way off base with that interpretation of what a clear statement is?
Well, that is Trump's argument, amazingly enough, that which is pretty much a ridiculous argument. I think the clear statement rule is actually uh, a rule of statutory construction. And yeah, it's made up because all rules of statutory construction are made up, basically. But all it means is, like, for instance, an example often given is the spending clause, which we just talked about. It has to tell the recipient of the federal funds exactly what, a clear statement of what is required in order to maintain those funds. That's the kind of context it's often used in. I mean, a statute is supposed to be clear. It doesn't mean that you have to name every individual who is subject to the statute. And that was an amazing argument.
Yeah,
So
because if they said everybody, they're not even talking about categories here. They just, specifically, like, this statute has to apply to the Secretary of Defense, or the
yeah,
statute has to apply to the congressman. Otherwise, they're immune. This is basically what I'm understanding it to mean, or what their interpretation of it is to mean.
well, and Sotomayor came back at them and said that that would mean that, the president's not subject to almost all criminal laws, which is, an absurd result. So she, by the way, well, we'll get to that, but
Actually, you're segueing me into every question here. As they did the day before, the four women stood tall for the moral values we as a nation should be trying to achieve. In particular, Justice Jackson, but you can also mention Sotomayor, spoke with passion and clarity in disputing Alito's claim that without total immunity, the president might be chilled in his performance. She said a criminal needs to be chilled from exercising criminal acts. She also said that granting presidents immunity from criminal prosecution could then turn the White House into a center for criminal activity. And I believe it was already a center from 2017 to 2021. I mean, even the first meeting they had in the Oval Office, where they had the Russians in there, and Trump was giving them the Israeli classified information, and it just went on from there. Please give your assessment of the performance of the women, Judy, on the bench during these hearings.
I think they were brilliant. And I include all four of them, actually.
I do too.
Uh, Barrett, as you pointed out earlier, she got down to the nitty-gritty of this case and said, is this private? Is this an official act? And so on. And then asked the question, since the guy was giving up so many, yeah, this is private, this is private. Well, then why can't we go ahead with this prosecution based on those? And there was a big discussion then of how that would be done. So I like that she was just grounded in the facts of the case. And Jackson, as you point out, tried unsuccessfully to bring them back to the case they were supposed to be talking about. It never worked, but she kept at it. And so I think that I liked that Sotomayor consistently stood up for democratic principles, as opposed to the cynicism, especially that Alito was showing about the government. Alito, who spent most of his life in government. But anyhow, I thought they were great. We need more women.
You're preaching to this choir here. We need more women. Aileen Cannon is about the only one I know of that I'd say, don't have a lot of respect for, but I don't know a lot of the women in the judiciary. But I'm looking at this case, this immunity case is a 5-4 decision, one way or the other. I'm thinking that Roberts, or no, I'm thinking that Kavanaugh, Gorsuch, Alito, and Thomas are going to vote as a block. And I'm thinking the four women are going to be the other block. And I think it would be up to Roberts to decide if Trump has immunity or not.
You might be right.
Or it could be that they don't really want to answer the immunity question and just say, we need to remand this so Judge Chutkan can do the work on figuring out what's an official act and what's criminal and what's private and all that. And like I said in the beginning, that's the way, to delay it, send it back up through all the appeals processes and stuff. But I think it's probably going to be a 5-4 in some fashion. Not really sure how they're going to do it. Given all that you know, Judy, what's your current attitude about this court?
I think the court is failing us. If Trump were to win and there was a Republican Congress, we might get all kinds of havoc. And in the past, as I have said often, the courts have been the ones, and the Supreme Court, but the lower courts as well, have been the ones to put a stop to it. And I don't think they're doing that anymore. And that worries me. So how do you handle Trump? I mean, can the voters be trusted not to vote for him? And can the media and the social media and Truth Social, are they that influenced by them? So it just seems to me like a very precarious time. And in my mind, the court is pivotal to trying to it's a pivotal place where disaster could be averted. And I am not sure right now that's what I see them doing. On the other hand, I can be a little optimistic. I think if things got bad enough, wouldn't somebody like John Roberts realize that, they really had to step up and not let things get out of hand too far, which may go along with your thought that he may be one of the votes, the good votes on the immunity case. But anyhow, I guess my feeling right now is they ought to be growing up and doing a better job.
You used the word failing us. Would you be willing to go as far as use the word corrupt in a description of what's going on there?
Well, maybe as to individuals. I think there's been some evidence of corruption on the part of Thomas and Alito. I don't know enough about the others. I don't want to be Gorsuch and say, what does corrupt mean? We don't know what corrupt means, which was another one of his great lines. But I don't know. As a whole, I don't think I'd go that far.
Okay.
But as to individuals, yeah.
Those two anyway would qualify for corrupt. Judy, this was an amazing discussion. Everyone on board knew how important it was, and I want to thank you very much for participating in it. All those out there in Cyberland, thanks for listening, and we'll see you next time. Bye now.